Good day once again. Welcome to part 2 of our lecture in Introduction to Law, PS 301. So here for this part, we will be talking about legal profession or law profession. Okay. So first of all, we have to define the definition, or we have to define the meaning of practice of law under the rules of court in Rule 138. And this is also how the Supreme Court defines practice of law in the case of Cayetano versus Monson. Okay? Under the rules of court, it refers to any activity in or out of court which requires the application of law, legal procedure, knowledge, training, and experience. So in whatever field you are, when you become a lawyer, okay, for as long as it requires the application of any legal principle, any law for that effect, in the application into real life situation and real life controversies and issues, then under the contemplation of Rule 138, you are deemed considered to be in practice of law. So any application of this knowledge and training and experience is considered to be practice of law. Now, also in the letter of UP Law Faculty, AM Matter, in number 10-10-4-SC, teaching law is considered practice of law because the fact that they're being law professors is inextricably intertwined with the fact that they are all lawyers. So it made clarification into defining the practice of law, because in the landmark case of Cayetano versus Monson, teaching law was not considered to be a practice of law. But insofar as this letter of UP Law Faculty, it was clarified that indeed teaching in a law school or organized law school wherever in the Philippines is considered to be a practice of law, because the fact of their being law professors is inextricably intertwined with the fact that they are lawyers. So basically, you cannot be a teacher or you cannot be teaching in a law school without passing the bar examination. So definitely it's considered as practice of law. It somehow widens the concept and definition of this term. According to Justice Padilla in his dissent in Cayetano versus Monson, the following factors are considered in determining whether there is practice of law. First is habituality. So practice of law implies customarily or habitually holding oneself out to the public as a lawyer. It is more than an isolated appearance, for it consists in frequent or customary action. So you should regularly appeal as being a lawyer or being in a legal profession to be considered one. Okay, so it is not only limited to single or twice appearance or two times appearance as a lawyer, but it is habitual, meaning you are doing this thing on a regular basis. Okay, so second factor, application of law, legal principles, practice, or procedures. What are these? It calls for legal training, legal knowledge, and legal experience. So basically, lawyers are required to attend seminars, no, for their MCLE as a requirement for the renewal, no, of their license. Okay. Also, compensation. Practice of law definitely implies that one must have presented himself to be the active and in continued practice of the legal profession, and that his professional services are also available to the public for compensation. In fact, there is a tariff for the notarization of document, okay, for the rate of acceptance fees, no, whenever you accept certain case, no, or whenever you have you have established a law office, and the IBP sets, of course, the fees, no, in every transaction, which is, of course, might encounter by your office. Lastly, attorney-client relationship, where no such relationship exists, such as in cases of teaching law or writing law books or articles, there is no practice of law. Okay, so this is what is being corrected by the letter of UP faculty, no, this case, because in the case of Cayetano versus Munsod, it considered teaching of law as not uh, it is not considered as a practice of law. But now it was clarified, okay, under the letter of UP faculty. Okay, in fact, when your teaching experience in law school is more than 5 years, okay, you can actually be exempted from MCLEs or yung mga trainings and seminars required annually for lawyers. Okay. So generally, to practice law is to give advice or render any kind of service which device or service requires the use in any degree of legal knowledge or skill. Hence, the Supreme Court declared that a lawyer economist, a lawyer manager, a lawyer entrepreneur, and a lawyer legislator of both rich and the poor as engaged in the practice of law. So when you, for example, pass the bar exams, you really have the option whether to work in the public or in the government, or to work in a corporation or a corporate world. You know, you can be legal counsel for different companies, you know, in the Philippines or here in Davao City. You can also work as a PAO lawyer or public attorney's office. You can work as fiscal or city prosecutor as well. Okay, you can also work in the different agencies in the government, the Department of Health, Department of Education, um, uh, Civil Service Commission, or in COA. Okay, so you really have the option of becoming engaged in a private practice by establishing your own law office or your work as a government officer. So practice of law is a privilege and not a right. Okay, the right to practice law is not a natural or constitutional right, but it is a privilege. It is limited to persons of good moral character with special qualifications duly ascertained and certified. The exercise of this privilege presupposes possession of integrity, legal knowledge, educational attainment, and even public trust. Since a lawyer is an officer of the court, a bar candidate does not acquire the right to practice law simply by passing the bar examination. The practice of law is a privilege that can be withheld even from one who has passed the bar examinations, if the person seeking admission had practiced law without a license. So basically, practice of law is really a privilege. Now, first of all, you have to pass, okay, and you have to pass the requirement right after the bar examination. Okay, so the passing the bar examination is not a guarantee that you can already practice law. Okay, it is not even a guarantee that you can already notarize documents, because you have to ask the court, okay, to become a notary public, right? So it is a mere privilege because not all Filipinos can be lawyers, or not all Filipinos are capable of being a lawyer. Okay, it requires a higher standard of skill and knowledge, not to mention the good moral character qualifications, the possession of integrity of every person who wants to practice law. Because in the practice of law, you will be dealing with lives, you will be dealing with the rights of your clients, okay? And you will also uphold the rule of justice and being an officer of the court, okay? Law as a profession and not a business or trade. Lawyering is not primarily meant to be a money-making venture, and law advocacy is not a capital that necessarily yields profits. Duty to public service and to the administration of justice should be the primary consideration of lawyers, who must subordinate their personal interests or what they owe to themselves. Okay, so basically the compensation you got is for the service you have rendered to your client. Okay, when there is already a lawyer-client relationship, of course, compensation is but proper and just, for a lawyer to receive, in exchange of the services he or she rendered for the protection of the right of his clients. And sometimes in corporate world, it is fixed by the company, upon employment of that particular lawyer. Okay, as well as in the government offices. Okay, the law, the compensation of the lawyer is fixed, unlike in private practice where their income depends on the clients they receive and the clients they have. Okay, sometimes, in other words, there is no fixed income in private practice or in law firms, because it would really depend on the how how maybe famous your law office is, or how famous you are as a lawyer, that you can already invite a lot of clients. But there is no fixed amount of compensation really in private practice. So every applicant, so what are the requirements for admission as a member of the bar or the bar? Every applicant must be a citizen of the Philippines, okay? At least 21 years of age, good moral character, a resident of the Philippines, and must produce before the Supreme Court satisfactorily evidence of good moral character. Okay? Before, during the, I think in 1950s, 1960s, okay, there's no requirement for you to take a pre-law course. Okay? So right after your high school, you can immediately go to law school and study law. But right now you have to, it's like becoming a doctor. No? You should uh, take a pre-law course, a bachelor's degree, and when you graduate, you can already take or you can proceed to the study of Juris Doctor. Every applicant for admission as a member of the bar must be that no charges against him involving moral turpitude have been filed or pending in any court in the Philippines. One example for this is falsification, estafa cases. You should have no pending cases, because otherwise, even if you pass the bar examination, you cannot sign your roll of attorneys because of that pending case. Pass the bar examination, must have complied with the academic requirements, you take the lawyer's oath, and sign the roll of attorneys. Okay, again, you must have no pending case. Okay, because even if you pass the exam, tapos meron kang pending case, you cannot proceed to the other requirement. Okay, all applicants for admission shall, before being admitted to the examination, satisfactorily show that they have successfully completed all the prescribed courses for the degree of Bachelor of Laws or its equivalent degree. So what are these prescribed courses? There are 8. Now we have civil law, commercial law, remedial law, criminal law, public and private international law, political law, labor and social legislation, medical jurisprudence, taxation, and legal ethics. Okay. Of course, you must obtain this in a law school or university or officially recognized by the Philippine government or by the proper authority in the foreign jurisdiction where the degree has been granted. That's according to the rules of court, Rule 138, Section 5, as amended by Bar Matter number 1153. Okay, so what if your grade is 74.9 or 74.8? Okay, at the requirement for passing the bar is at least 75. Okay, kahit 0.1 or 0.5 pa yan or 0.2 pa yan, kulang sa iyo to get that 75, then it will still be considered as a failure. Okay, kahit ilang point pa yan, dapat you should reach in the bare minimum 75. Okay. So good moral character, lawyers have been repeatedly reminded that their possession of good moral character is a continuing condition to preserve their membership in the bar in good standing. The continued possession of good moral character is a requisite condition for remaining in the practice of law. So what do you mean by good moral character here? You must, of course, maintain and preserve the the character of integrity, no possession of the integrity. That means that you are not supposed to be violating any law because otherwise that would be that would jeopardize the image also of being a lawyer. And of course, should not violate any laws. Okay. Um, Sometimes this is the reason why lawyers are being punished now by the Supreme Court. Okay. Sometimes it would depend on the gravity of the act committed. Sometimes they get suspension as a penalty. Sometimes also they get really disbarment, no, meaning they are already disqualified for life, not to practice law. So reacquisition of the privilege to practice law under RA 9225. So a Filipino lawyer who becomes a citizen of another country and laterally acquires his Philippine citizenship under RA 9225 remains to be a member of the Philippine Bar. Okay? However, the right to resume the practice of law is not automatic. RA 9225 provides that a person who intends to practice his profession in the Philippines must apply with the proper authority for a license or permit to engage in such practice. Okay. Um, let's say you're a lawyer now, and then you renounce, for instance, your citizenship as a Filipino and you become an American citizen. Later, and you wanted to come back here in the Philippines and you want to reacquire your status, no, of being a lawyer here. Hence, you want to practice law again here in the Philippines. So you must undergo that process as required under our 5. So we also have law student practice rule under Rule 138-A. A law student who has successfully completed his third year of the regular 4-year prescribed law curriculum and is enrolled in a recognized law school's clinic legal education program approved by the Supreme Court may appear without compensation in any civil, criminal, or administrative cases before any trial court, tribunal, border officer to represent indigent clients accepted to the legal clinic of the law school. So under the new rule, actually, it requires the approval also of the school. Okay, so that you can invoke or perhaps practice, no, under the law student practice school. Okay, so that ends our lecture on legal profession. Okay, for the part 3 of this lecture, we will be talking about the code of professional responsibility.